Going for a second.
Good. Okay. Okay, good evening, everyone.
Pretty well.
Welcome to the November 20th meeting of the Hamilton Planning Board. Excuse me, it's a few minutes after 7 o'clock. On the agenda tonight is tree removal public hearing for a number of trees to be removed on scenic roads in town. We also have a continued public hearing for definitive subdivision plan for 601, 605, 609, and 613 Bay Road. Continued public hearing. We have a board discussion, a presentation on a request for the board to consider creation of a special permit bylaw to regulate medical marijuana facilities. We'll also be talking about our master planning update for housing, for the housing portion. We may be talking about future bylaw amendments, meeting minutes, and also updates from other members of the board. So Tim Olson, our DPW director, is first on our agenda tonight to discuss tree removal on scenic roads.
Yep.
Tim?
Thank you. Tim Olson, Director of Public Works. I've just come before you tonight as in accordance with the scenic road bylaw. We look to do some maintenance on some trees on a few of the scenic roads in town. Part of the bylaw is to get permission from the planning board to do the work. The trees are dead, diseased, and dangerous as determined by a professional arborist, Mark Sikoria. Mm-hmm. So we just asked for permission to just do our annual maintenance on trees. It might not be the last time in front of you, but this is the first round of trees this year.
Are they marked? You've marked them, I'm assuming?
They are marked, yep.
Great.
Yeah, and then I have the tree hearing scheduled for next Tuesday, the 27th, at 5 p.m.
Yep. Okay. So Patrick, what is we need to approve these trees being removed exactly, or
that's
okay, before the hearing, ideally.
Correct.
Okay. I don't know if anybody's had a chance to drive by any of the trees or not. I have not.
I've seen the one on Union Street, and it is definitely dead.
Yeah, that one
I'm sure you've seen it.
That one I know.
So I make a motion we approve the request of the DPW director to remove the trees.
Any more discussion? All those in favor?
Aye.
Aye. Opposed? Unanimous.
Thank you.
Okay, thank you.
Thank you.
That was quick.
Thank you.
Next up is continued public hearing for definitive subdivision for 601, 605, 609, and 613 Bay Road.
Sorry. Just real quick, there was conversation.
Identify yourself for.
Tom Ford, 609 Bay Road. There was discussion last week about the Rayo Gismundo lot across the street, and we agreed to take some pictures coming out the driveway. I have enough to share, I guess, but
please.
Yeah. Tom, can I make a comment before you start?
Sure.
I did essentially the same thing you did, sort of, except I didn't take any pictures. And I could see the reflection, it was this morning, I could see the reflection of my headlight on the fence, and it's just about the same as you show it in this picture here. And I got myself as close to Chris Shepard's side of the driveway as I could get. So
that's what I did too.
Yeah.
And I did it in the daylight, which is a little less telling.
Okay.
The headlights at night are a little better.
Yeah.
And then the Rick Salvo pass out, the bigger one, was actually designed to show you the changes that we made to the plan with respect to the fire chiefs. We need a circular turn, and it shows that. But if you look carefully, you can also see the orientation of the drive with respect to the Braille Gismondo lot. On the plan, we've also added on, I believe it's sheet 4,
Yes.
a note to the effect that everybody was interested in this drive won't be used for any, cannot be used for any further subdivision.
Or access to any other property, right? Yeah.
It actually says access to any other property.
Access to, I'm sorry.
See it.
Ed?
There's been some changes of the Historic District Commission, and it's,
Can you speak
And
into
it's
the
community.
microphone? Can you speak into the microphone, Ed?
I'm sorry. There's been a memorandum from Donna Brewer, our town council, in relation to the Historic District Commission holding hearings on particularly the, how does she describe it?
Widening.
The widening of the ways does need some level of Historic District Commission review. I really, I'm chairman of the Historic Commission, so that's the reason I'm speaking tonight, even though I'm also a member of the Planning Board. Rick, am I speaking loud enough?
Yes.
Yeah, okay, thank you. My first inclination was, if nobody stepped forward and asked the Historic District Commission to hold a hearing, I would leave it, let a sleeping dog lie. But with Donna Brewer's opinion that the Historic District Commission should hold a public hearing as to the appropriateness of the roadway, then I really, as chairman, have no choice but to schedule a Historic District Commission meeting.
Yeah, she gave you the choice of holding a public hearing on it or just a meeting, whether or not you want to get into the full
I
public
could
hearing
hold a
process.
meeting, but if I don't hold a public hearing, the commission is always subject to speculation of us not doing our job well. So it's one of those, the commission can overrule me and say we shouldn't do it or can do it, but I think the basic thing will be that we should hold a public hearing and let the public say what they want to say, and then would rule accordingly. The only other areas that I gave thought to during the past week that the Historic District Commission might have some influence or some thought on if there was public street lighting involved, but as I understand it, there's no public street lighting, and I guess that's where I'm at, yeah. Oh, and there's no, just my other thought is there's no architecture involved, no building or what have you to be involved. It is strictly does the roadway in some way affect the historic district. So that's where I'm up to date.
Right, okay, thank you, Ed. Any other comments from the
How
board?
quickly we can have that, but we'll get working after Thanksgiving.
Any other comments from the board?
So, how do you think we should proceed? We can either approve it provisionally, conditionally, subject to the Historic District Commission's ruling,
Correct.
or we can wait.
We can close the hearing, our hearing,
Right.
and then we have, I'm sorry, you said 20 days, Patrick? Is there any chance you could have a meeting in 20 days?
Yeah. I've got nothing to do between the holidays.
So according to Patrick, we can close it tonight. We have 20 days to render a decision. We could wait until they have their meeting, subject to it being within 20 days, and then submit our decision. or we could vote tonight
Either one is fine with me.
and make it subject to theirs, right? I mean, it's, you know.
I would prefer to just go ahead and vote tonight,
Yeah, so would I.
bring it back. So do you want me to make a motion?
Sounds like a good idea.
Any more public questions before you go?
Sure.
Paula Jesmundo, 610 Bay Road. Just three things. One, I'd really be interested in seeing what was distributed to you with regard to the headlights on our property.
Please.
I don't know what that shows.
Complain that this is.
They're pulling out from this side going.
Yeah, so clearly from the other angle you would see the lights, but.
Yeah. Secondly, it's really important to us that there be a note on the plan should you approve this subdivision, which it seems like you're going to do, that the road, first of all, I don't know what it is. Is it a road? Is it a drive? Is it a driveway? Is it a roadway? What is it?
I think way is the proper term here.
It's a private way.
It's a private way.
Okay, so it's not going to be like
No.
serviced by the, is it a road that falls within like
No.
the subdivision?
No, we answered this question last time.
I know, but we were unclear.
And per your request, and the applicant has put it on his plan, specifically says that this road shall never be extended to connect with another.
Never be used
Is
to
that-
accommodate further subdivision. I just think the wording is important. I mean, we all know what it's intended to do, which is to prevent the use of the road to create a U with the pools.
Take a look at the note on the,
Okay, that's good. And if I could just make a statement, as a resident of the Historic District, I grew up in this town over on Kennedy Road, and for me, to live in the Historic District was a privilege. It was something I wanted to do. I was looking for property in the Historic District. I know, people have said to me sometimes, like in regard to the cell tower, oh, you guys in the Historic District, if you care so much about it, you should, drive horse and buggy or something. And that's not the point. The point of the Historic District is to preserve this very small section of Bay Road in Hamilton with some sense of its historic significance. And it costs us. For instance, when I added on to my own home, I had to come before the Historic District, and they put limitations on me. I had to have true wood divided light windows. I couldn't use a window to pay thousands of dollars for my front door to use that I thought would be attractive. I need a door on a house of similar age down in Wenham, and we had them reconstructed. There's a cost to living in the Historic District. And I understood when I bought into the Historic District that was the cost, and I don't object to it. But that, it needs to be appreciated by the public that voted the Historic District into existence. And it needs to be appreciated by other people who move into the Historic District, that when you do this, you take on the burdens as well as what I consider the privileges of living in the Historic District. So I would really hope that there would be a public hearing on it. I know that when the Fords, when Tom went to originally develop that property, and we were before the Historic District on it, that the Historic District Commission cared a lot about the appearance of that roadway and the way it met Bay Road. I'm not an architect. I don't really have that historical background, but it's significant to me. And I hope to other residents of the historic district, and I hope to people who live in the town that voted this district into being, that we respect it. So that's, I just would hope that there would be a hearing on it.
Thank you. Tom.
Just to respond briefly, the 3 houses that I built on Bay Road, 2 rehabs and 1 new, all went through that process. I hired a really great architect to help, and the 2 that are remaining are both in the district and will go through a similar process. I have not been treated unfairly by the Historic District Commission. I don't quite agree with Donna McKenna's interpretation, but I'm still well pleased to go in front of the Historic Commission and let them weigh in on the road. But any implication that we did anything but respect and improve the view from the district,
I don't mean to imply that, Tom. I just think that they need to weigh in on it.
I think that's fine. I think it's consistent with other ones. I don't particularly believe it's right on the driveway, but reasonable people can disagree.
Thanks, Tom. Any other comment? Holly?
Hi, I'm Holly Shepard, and I live at 613 Bay Road. I was not here at the last meeting, but I was able to read the minutes from last week, and so I'm going to try not to be redundant, but this is my chance, I guess, to stand up here. But I just wanted to speak today or tonight in support of Heather and Tom Ford's subdivision plan. Basically, for one basic reason, it's an important one, is that it beats the alternatives that could possibly be there. I understand. It seems that there were comments and discussion around the assurances that we certainly have received from Tom and Heather regarding no further extension of the road would occur and no access to other adjacent land. Also, the restriction of no further subdivision. It seems like you, I don't want to go into that. It seems like you have talked in depth about that, but I wanted to, I guess, sort of address 2 more things. One is the current and future lighting and traffic concerns. I know that the Breos and Gismondos are concerned about the car lights that go that could possibly go in and out. But and with all due respect and with a lot of sympathy, we really deal with much more of that actually in our own house. Where our house is situated, most of anyone who's taking a right-hand turn into our driveway, we get headlights in our family room, our dining room, our den, our master bedroom. But again, it's something that we feel that we could work with to possibly diminish that effect on it, but I don't think that we want to not go through with this because of the possible alternatives beyond that. So I know what they mean, and I want to just recognize that concern for them, but for a house, even for a house like us that gets headlights all the time, it's not enough for at least us to not take this subdivision seriously. And that sort of leads into more of where I wanted to go, and Chris and I talked a little bit just about how it's all going to affect our family, and we certainly love where we live, and I agree with Paula, who just spoke about living in the historic district, and it's really quite a privilege to be here because it does, it's a beautiful area. But what we feel beyond the fearing the other alternatives, the intent for similar houses, similar lots with similar market values that will be kept in keeping with our historical district look and feel is exactly what all of our abutters, the abutters of this land should want as neighbors. I also want to confirm Tom's comment last week about the current interest in the properties. We have several friends that have already sat with Tom and a couple more that will be speaking with him. And that's kind of a nice connection that we have. So also the idea of a private way that's off a very busy road with a cul-de-sac at the end. Personally, for my daughters to ride their bikes around, perhaps some of their friends, is something that we haven't or don't have in the current situation living on 1A. And so I was sort of trying to take it as looking at the glass half full rather than the glass half empty. And so in conclusion, we understand there's no such thing as a guarantee, but we think by supporting Tom and Heather Ford's current subdivision plan, we are assuring ourselves of the best possible chance of an outcome that we could not only live with, but actually enjoy. So members of the planning board, thank you for your time and allowing me to be heard.
Thanks, Holly. Any other public comment? Any other comments from the board?
For the motion?
Sure.
So I move the approval of the subdivision plan for 601, 605, 609, and 613 Bay Road, subject to review by the Historic District Commission.
Second?
Should we also put into that any conditions that we want to potentially, or do we have to list the waivers out? That's the other question.
I think I would have that as a separate item. Another motion.
Yep, okay. Okay. Okay, all those in favor of the motion?
Aye.
Aye.
Aye. Opposed? Unanimous? So we need to make then a second motion.
Right, I'd make that
To-
as a second motion. And I'd also include the fact that these are revised plans.
Yes.
So I was not here last time for all the waivers you talked about. So I'm
Yeah,
just,
I mean, they're all listed.
You're right.
On the front page.
so a motion to
so-
include in the plan. It's not in the, it's in the requested here. Right here, you're asking me to read that?
Yeah.
Waive section VC2C to allow no tangent between reverse curves where
Oh,
one.
I don't think you
is that
have to
the one?
read all of them.
You don't have to read all of
Just
them.
to list, to include all the waivers listed
As long
on
as
the
we can
plans?
reference this plan
Right.
with these waivers,
1 through 7.
1 through 17.
1 through 17.
Yeah.
So I move to accept this plan with the listed waivers as the official.
Is there a new date on this? I see October 1.
There's a revision date,
Where is,
Is it just on the?
11/13.
so accept
There
the
we go.
plan on
11/13, yeah.
Thank you.
11/13, which includes the 17 waivers as the official plan?
Second?
Any more discussion? All those in favor?
Aye.
Aye. Opposed? Unanimous? Thank you.
Okay.
I think you have to close the public hearing. Do you?
We do.
Oh, sorry.
I'll make a motion to close the public hearing.
Second?
All those in favor?
Aye.
Aye. Opposed? Unanimous in favor?
Thank you for all the consideration. Appreciate the
Thanks,
time.
Tom. Okay, next up is a request for the board to consider creation of a special permit to regulate medical marijuana facilities. Can you please step to the podium, please?
Sure.
Thank you.
Would it be possible to take about a 5-minute break for me to set up a PowerPoint projector?
Of course, yeah.
You wanted to clear it?
Can you,
We'll just take a quick 5-minute break.
then,
Thank you. Sorry.
Did you have a big?
Last time.
hoping it would discourage him, but I'd heard that some source told me that, oh, it's gonna be 200 units, and the plans are, has he filed his PEL?
If he has, I haven't seen it, and the selectmen are supposed to get it
Go to the front
after
page, it's easier.
he submitted it to the state. So, to my knowledge, nothing's been submitted.
Right like that.
So
Yeah.
that was probably a misfiring. I think it
I'll
was,
show you on the picture.
Same news or something. Said that
My
they were
lights
going ahead and so
came-
forth,
Did not come up to this fence. That fence post right there. This is about 12 feet long.
Plan is to do this.
And it's an 8 foot. It's got to be about a 7 foot high, because I don't know what that is, but that's no more than 6 feet.
Make more worries, that's
Seven.
all.
Well, which we knew was gonna happen.
These are the windows they're talking about that they want the lights shown. Well,
Oh, it's just that you
know
read
that it was
that.
when I was parked here,
And this
you
is
see,
maybe a
this guy has a little bit more, because you can see the shadow there. Okay. And
Yep. Thanks.
my lights ended right about there, somewhere like that, and they didn't come up any much higher than about.
Turn them back on, I just.
Okay,
Okay,
yeah.
yeah.
Oh, it's filthy, it's gross, it needs to be painted.
Ben Timon's
That went off, please.
presentation. I know that most members of the planning board are aware that Green Meadows Farm Stand in operation discontinued this past spring. I'm sure they as a family evaluated what to do with the property and made a decision to pursue a medical marijuana operation. I know Mr. Patton, who's here tonight with us, and the town have worked together, particularly with the Board of Selectmen, have been discussing this project for quite some time. I do want to make sure that people understand that we do have a recreational marijuana ban here in town. However, we don't have a specific bylaw for medical marijuana facilities. But I do want people to be aware that we have many other protections that do cover the town and abutters. The state has very rigorous laws in place to manage these operations and give host communities many protections. I will tell you that one of the laws is to require a host community agreement, which was sent to each of the board members. It's dated August of the 20th of this year. Mr. Patton and the Board of Selectmen worked with abutters, as I understand. I have copies of many of the emails that went back and forth trying to address concerns as part of that as they were teeing up the agreement. I can tell you that the agreement does allow the town and the proponent to work out concerns before permitting, during the state process, but after permitting as well. I will also notice that the HCA does, as you read it, it does address noise, smell, use of consultants, gives the planning board the site review responsibility as part of the town. That was part of the Board of Selectmen and Mr. Patton's agreements as part of the HCA. That said, the town does have a fairly extensive level of control, even if there are unanticipated things that do arise as part of the project and process over time, and it does require the proponent to address them. I'd also like to close by saying and giving people some comfort that the host community agreement in one of the sections actually has a termination clause that says that the agreement ends if the company fails to comply with the agreement, including any of the conditions that may be placed upon the site plan review and approval. So I did want to give people the benefit of the work that's been done heretofore. I'm not sure where the project is in terms of the state review process, but I can tell you that the selectmen did work extensively with Mr. Patton, his counsel, as well as our counsel. So I wanted people to be aware of that on the board as well as at home.
Great. Thank you, Patrick.
Thank you, Mr. Chairman and the board, and Mr. Reffitt. My name is Ben Timon. I represent two of the abutters to the Green Meadows Farm site, Paul Grandpré of Hamilton, who's here, and Chris and Deborah Abbott of Topsfield, who obviously are not Hamilton residents, but are direct abutters on the Topsfield side. Mr. Grandpré is going to ask to speak after my presentation. He lives at Patton Ridge, and I would like to convey some of his concerns and perhaps some of those of other Patton Ridge residents who weren't able to make it, I think in large part due to Thanksgiving plans and the like. I do have copies of this presentation I'd like to distribute if I could. Mr. Patton? 3 copies for you. Thank you very much. I appreciate that. And there's going to be 7 here. 1 and 2. 1, 2, 3. Thank you. Thank you. Mr. Chairman, since I did not bring anybody with me this evening, if it's with your permission, I'd like to go over to the PowerPoint so I can move the slides.
Absolutely, yeah. We have a microphone for you, so just please speak into that, and I think the camera can make its way over there.
Great, thank you. I think we can turn this off. So, okay. All right, thank you. So this is a 24-slide presentation. I'm going to try to, get through it as promptly as I can, and naturally, whatever questions the board has, either during the presentation or afterwards, I'm certainly happy to answer those questions. A little bit about me: I'm a land use litigator. I am often on the developer and owner side of cases. On occasion, I'm on the opponent side of cases. I do a lot of 40B work. exclusively on the pro 40B side. In this particular instance, as I mentioned, I've been retained by two of the direct abutters who have concerns about what they've heard with regard to the Green Meadows Farm proposal. But really what we're here to present to the board this evening is our appeal to you that you ought to get behind a fairly conventional medical marijuana zoning bylaw that doesn't exist in the town's bylaws at this stage.
Just a quick question. Were your clients involved in the discussions with the selectmen in developing the community host agreement?
Not that I'm aware of, Mr. Mitchell. I know that Mr. Grand Pré, who's here, has spoken publicly at a prior meeting, and it perhaps was a Board of Selectmen meeting. Unless I'm incorrect, Paul, I don't know that you were involved in the HCA negotiation. So, no, and I can say I know that my clients, the Abbotts, weren't, but they live in Topsfield, so that would probably make sense that they wouldn't have been included in the Hamilton discussions.
And just for clarification, is your Topsfield client opposing the overlay district regulating marijuana abutting his property?
Yes. In fact, we filed an appeal in the land court in August or September of that particular bylaw. Because the patents had not proceeded under that bylaw to seek a special permit in Topsfield, it wasn't a special permit appeal. That process never took place, but it was a challenge to the bylaw itself. We challenged it as spot zoning because what Topsfield did was they created an overlay district that was a piece of the Route 1 corridor in Topsfield, and then the single Green Meadows Farm lot that exists in Topsfield, which we regarded as unlawful spot zoning. We challenged that in the land court, and without getting into all of the merits back and forth, the patents attorney, Gavin Cockfield, indicated in court that the patents were not going to pursue building under the Topsfield bylaw at this time. I think that's an accurate statement. And that was reported to the judge, and we withdrew our appeal of the bylaw without prejudice, with the ability to pursue it again should the patents change their mind with regard to the Topsfield bylaw.
Okay, so for the purposes of this discussion, there's one person in Hamilton who's hired you to present this proposal.
That's correct.
And are they an opponent of the medical marijuana facility as proposed?
Well, we don't know exactly what is proposed at this point, and so, I mean, Mr. Grand Pré can speak for himself. I know that he has concerns about living next to a medical marijuana cultivation facility, but what I've been retained to do is to ask the planning board to get behind a medical marijuana bylaw, which, as I'll explain in here, is really our request to the board to simply create a level playing field for use of this type and the type of bylaw that actually exists in almost every other North Shore community. But I get into some detail regarding that in the presentation. So, and some of this, you may well be aware of, but in Massachusetts, obviously both medical and recreational cannabis are legal, and cities and towns, under certain circumstances, as Hamilton has done, are allowed to ban recreational marijuana establishments, but are no longer able, according to Attorney General guidance, able to ban medical marijuana establishments. Obviously, in the news today, we heard about the two recreational dispensaries that have opened today, so that's obviously unfolding at a rapid pace as we sit here today. Municipalities have a responsibility, in our view, to manage and control this use within their borders, as you would, virtually any other type of use that is subject to zoning. Virtually all of the communities on the North Shore, and we'll put up a map in a minute, do this through their zoning bylaws, seek to regulate medical marijuana through their zoning bylaws. If you don't do that, and Patrick alluded to this, I believe, in his opening. Marijuana businesses can be as of right anywhere in town. So as it stands now, there's no overlay district, there's no regulation at all, and a medical marijuana facility has an as of right ability to open anywhere in Hamilton. The Cannabis Control Commission is now the agency that regulates both medical and recreational marijuana on a statewide level. It had been the Department of Public Health for medical, and I believe that most, if not all, of DPH's duties have now transitioned to the CCC. They put out a document, guidance for municipalities regarding marijuana for adult use. I highlighted a couple bullets from that. In 2016, the Massachusetts legislature, in response to the ballot question that legalized medical marijuana, exempted cultivation of marijuana from the agricultural exceptions of Section 3 of the Zoning Act, Chapter 40A, quote, therefore retaining local control over the placement of marijuana establishments. Among the requirements that any medical marijuana business must achieve in order to get state certification is that it get municipal zoning approval. So the state process has nothing to do with zoning. That is left, in the words of the CCC, to the local control of cities and towns. In 2017, Hamilton, as you know, held a special town meeting in the fall, and they approved a ban on recreational marijuana establishments. But when you did that, or when the town meeting did that, they created a fairly large loophole with regard to medical marijuana dispensaries by exempting medical marijuana dispensaries from the definition of marijuana establishments. So marijuana establishments are banned in Hamilton, but medical marijuana dispensaries are not. Now, there's some confusion, perhaps, in the terminology, because the patents are not seeking a small d dispensary. They're seeking to put forward a cultivation facility. But under the medical marijuana regulation, that term, medical marijuana dispensary, encompasses cultivation as well. It essentially encompasses all medical marijuana businesses. And that exemption and loophole was there, put in there presumably to allow the patents to move forward with their plans on Green Meadows Farm. One of the problems that we see is that with that loophole in place, others could follow suit. Now, there is a host community agreement process that Patrick referred to and that I'll refer to as well. And so it's true that that is a process that any person seeking to open one of these businesses would need to follow. But as a matter of zoning law in Hamilton, you know, any one of us in this room could seek to open a medical marijuana dispensary any place, you know, next to Crosby's, whatever. There's no special permit process. There's no overlay district. It's an as-of-right use. This is repeating myself, but the bottom line is that Hamilton currently is not retaining local control over the placement of marijuana establishments by virtue of the loophole that is in your bylaw and the absence of regulations in the bylaw.
Quick question.
Yes.
Is it just possible for the town to just not have a host community agreement with someone else, let's say?
Yes, it's possible. I mean, I haven't seen it happen, and I've been involved in a couple of these cases in other parts of the state, and usually I've never seen one not consummated. You know, sometimes there are disputes over the amount of revenue that's going to be coming back to the town. And I don't know that the denial of one, if there ever has been a denial, has been litigated. So I think that theoretically the answer is yes, but from a practical standpoint, I've never seen it.
Well, it's still pretty new.
And it's new, exactly, yeah.
So theoretically, though, the town, the selectmen, could say, we don't want it anymore, and not invite them in, not agree to a HCA with them.
Well, not agree with an HCA with them, but the basis for not coming to an agreement on an HCA would really not have much to do with zoning or zoning issues, because as it stands now, it's as of right for zoning. So you know, the HCA deals with a lot of the particulars, like how much money is going to be paid back to the town, et cetera. But, you know, again, we'd have to see what would happen in a court, but I am very skeptical that a Board of Selectmen could simply say, well, we don't want any more, and we're going to accomplish that by not agreeing to HCA's. It's a matter of zoning like any other type of use, you know, where you have something that's either allowed, not allowed, or allowed by special permit, and this is allowed as of right as it stands currently because of the lack of regulations in the zoning bylaw.
So, go ahead. No, go ahead.
Okay, I'm getting confused. What I don't understand is why do we need to regulate this in the sense that this is a medical marijuana business. They're going to be in the business of growing, but not necessarily selling in the town? This is a wholesale business in a sense?
That's my understanding, yes.
Okay. Why do we care how many there are? Because if there's, they would each be, first of all, be able to get whatever the appropriate section under Chapter 61, get that kind of tax support. The business would, but they will, in some sense, increase, I would think, the value of the land and potentially the amount of revenue to the town. And it's almost like setting up a monopoly of one business versus many businesses. And why aren't we, you know, in another sense, wouldn't, if we do it with this, why aren't we doing it with all types of businesses? And since this is agriculture, all the horse farms that are around. I don't get the difference.
Sure. Well, a few things. So first of all, the legislature, has determined that this is not agriculture in terms of traditional agricultural exemptions. So one of the earlier slides where I mentioned the legislature specifically took this particular use out of the agricultural exemption. So it's not considered agricultural from a zoning perspective. The exemption in the Hamilton bylaw and the ban that you passed allows for, quote, medical marijuana dispensaries, unquote, and that term in the regulation encompasses medical marijuana dispensaries, as you would assume, and medical marijuana cultivation, which is what the patent family is seeking. And so you may not care about any number of cultivation facilities coming in, although further on in the presentation we get into what some of the objectionable impacts of cultivation facilities are. So I'm hoping I might be able to persuade you that it's not, wouldn't be a great thing to have them all over town. But as it stands now, there could also be, under that same analysis, an unlimited number of medical marijuana dispensaries, which some people might find more objectionable, particularly if there were a lot of them. Right now, there's no, again, that's all as of right from a zoning perspective.
Okay, I understand that, but it still gets back to, there's no, the closest thing that in my mind that comes to this same kind of business would be pharmacy. And there's no limit on the number of pharmacies that can be placed in town. I'm just
right. Well, I think I'm
not trying to say yes.
No, I understand. No, and I haven't studied the bylaws with regard to pharmacies, but my guess is that, you know, pharmacies are allowed by special permit in the commercial district and not allowed in the residential district, and so none of that type of conventional basic zoning exists with regard to this use in terms of placement or anything else.
Okay, so if we made it if we just took the broader term of dispensaries, dispensaries would probably be, Brian, help me out, would dispensaries be limited only to the commercial district? Could I set up a dispensary in my house?
It's a commercial use.
No, you cannot.
No, that's what I meant. No, you can't.
Yeah, right. Okay, so
commercial use.
that limits it.
Right.
Would you have to come before the board for approval regardless?
Yeah.
Right, but again, you've answered the question. Pharmacies are allowed in, I assume, by special permit in the commercial district. medical marijuana dispensaries are allowed anywhere in town as of right. So that's the difference.
Well, I mean, a pharmacy
I
would be
would-
allowed by site plan review
Right, but not anywhere in town.
in the commercial district, yeah.
But if you're selling
not
it,
in residential
why would you
districts.
not be subject to having to be in the
It would be in the commercial district.
commercial district, rather than, you couldn't be in a residential district if you're selling something.
Right.
Right.
So it's not really any place
You're
that
talking
could have
more
a
of the
dispensary.
cultivation. He's talking more of the cultivation, I think, of it.
Yeah.
being-
No, there is nothing in your bylaw that limits the placement of medical marijuana dispensaries, period.
Right, and in fact, the bylaw allows it, right?
Right, the bylaw specifically exempts medical marijuana dispensaries from the ban, and there's nothing else in the bylaw
Right.
that limits, regulates, restricts,
Right.
does
And-
anything with regard to medical marijuana dispensaries.
Right, and that was passed by 2/3 the majority of the town meeting.
Right.
Right, so the voters have already spoken on dispensaries.
I doubt that this aspect of it was
No,
fully aired, but
so I think you probably want to leave that alone, because that's a
Okay.
rat hole that's not going to get you anywhere, so why don't we continue on?
sure. No, I'm just answering
Right.
the questions that are being
Right,
put to me.
no, I understand, but
Right.
it's sort of, we're going to get
You
in.
might think this is a rat hole, but I think it's important, this particular slide.
No, I meant on that
Oh, okay,
particular,
right.
that particular.
Yep. Although this relates to the same issue, because we did the research for essentially approximately a 10-mile radius from Hamilton. We looked at the zoning bylaws of all of the towns that are listed on that slide, 20 some odd towns. And Hamilton is the only town, and again, you know, maybe some people might wear this as a badge of honor that Hamilton's going to be different than others, but I'm just pointing out the facts to you that Hamilton is the only town that is in this particular posture where it has no regulation whatsoever of medical marijuana dispensaries, or has the kind of loophole in the moratorium that you have. There are some towns that have done a moratorium only, but have not, you know, exempted medical marijuana dispensaries in the definition in the way that Hamilton has. And it passed by 2/3, as Mr. Mitchell said, and maybe the people at town meeting thought that that was great, but we think that Hamilton is definitely an outlier with regard to the regulation of what is a pretty intense use.
Right, and then, so this is where I'm getting, you know, we're getting lost in dispensaries versus cultivation. As I understand it, your clients are concerned about the cultivation and
Right.
its impact on their
Correct.
their property. So that's why I'm
Right.
advising that we stick to the cultivation.
Okay, that's
so
fine.
So I have a further comment,
Mm-hmm.
because I looked at that list, and I found it a little bit difficult to believe that some of those communities had or didn't have
Mm-hmm.
medical marijuana bylaws. So I actually talked to several of the planning directors, starting in Hamilton.
Okay.
Wenham, excuse me.
Right.
They have the exact same bylaw we do, and they do not address the cultivation of medical marijuana at all.
Right.
Neither does Boxford, that's on that list.
Right.
And several other communities
Right.
don't have any medical marijuana
Right.
cultivation bylaws.
Right.
Ipswich does have a special permit, but it's to go into their industrial district.
Mm-hmm.
Danvers has one. It's by right in their, it's an overlay district, and it's by right in their industrial zone.
Right.
So I think that this is a broad brush sweep, that making those kinds of statements undermines
Yeah.
your particular case, and is
Right.
doing a disservice to your client. If you're making this kind of broad brush statement, and I'm pointing this out because I want this to be fact-based discussion.
Yes.
So we need to keep it
Right.
to the facts that exist in reality now.
These are the
So-
facts that exist in reality now. I only deal in facts, Mr. Mitchell, and as I said when I introduced this slide, all of these other towns either regulate medical marijuana in their bylaws, or they have a moratorium that does not have the loophole that Hamilton does. So Boxford and Wenham are two such towns, as you suggest, that have only done moratoria, but did not take that extra step of creating this giant loophole that was put in place for the benefit of the patents.
Right, and that's why I'm trying to stick with the cultivation issue, because supposedly that's what your clients hired you to do.
Yes.
So we keep going back to the dispensary as a critical issue here, but nobody, quite frankly, that I've heard, is disputing the dispensary allocation in the town of Hamilton. Your client is disputing the cultivation in the town of Hamilton. So I'd like to stick to that.
Yep.
And
no, right. I'm just saying that the planning board, one reason that the planning board may want to put forward a bylaw is because dispensaries could be put anywhere in town right now. So that's just an additional reason why the board may want to consider that. Marijuana zoning bylaws require boards to weigh impacts. Now, these are all the impacts that this board is well familiar with, because they're the kinds of impacts that are studied in just about any type of special permit proceeding. And I'm going to talk a little bit about each one, although quickly, because I realize you have other things on your agenda. But noise, odor, visual impact, light pollution, water usage, wastewater generation, risks to rivers and streams, safety risks, and diminution of property values, all run-of-the-mill kinds of impacts that you deal with, and they're very, very relevant with regard to marijuana cultivation facilities. So, again, nothing that you don't know. Why do towns put overlay districts in place in the first place? To control placement. You know, we talked about pharmacies. Pharmacies are allowed in commercial districts, not in residential districts. Controlling placement. Promote municipal planning. So there's some idea of, you know, where the planning board would like certain uses to be and where it wouldn't want uses to be. To avoid incongruous uses. And to give public notice and create transparency. As it stands now, there is only a site plan review process that would be available for an as-of-right use, and at least under most circumstances, and I believe it would be the case in Hamilton, there isn't a requirement under 40A, certainly, to notify abutters of a site plan review process like there is for a special permit process. So that's where I get into public notice and transparency. A special permit process is, in our view, a much more appropriate way to handle something like this. Patrick mentioned the host community agreements. I respectfully disagree that should be the one way that this use would be regulated. It's, again, it would be an outlier with regard to other towns in the area. And as the board knows, there's a big difference between contractual obligations and zoning. You can have a developer and owner that breaches a contract. The remedy is to seek damages in court. There is perhaps a termination clause for the HCA, but zoning exists for a reason and is a much more durable way to plan land use, and that's obviously what this board's bread and butter is, dealing with zoning. But the HCA in this case has a provision that's very similar to the one that's on the slide, and it's listed as a model host community agreement condition by the CCC in their guidance document, where it says that the town, municipality, makes no representations or promises that it'll act on a license or permit, including a special permit or other zoning applications, in any particular way. So these are separate matters. There's the host community agreement, which in all cases that I'm aware of, including in Hamilton, says, look, we're agreeing to certain things here. It has nothing to do with the requirement that you go and get a permit. And in Hamilton's case right now, again, it's site plan review, which is, as you know, an as-of-right scenario, versus a special permit, which we think would be a much more sensible way to do it. Why do towns carefully regulate marijuana businesses? Whether it's dispensing or cultivation, production, it's a high-impact use. I mean, it's a controlled substance. It's still unlawful under federal law. It's very tightly regulated for a reason. It's subject to stringent regulations in all other respects. And again, it's just, in our view, a matter of basic prudence that a town would want to try to exert some control over this use through its zoning bylaws. These cultivation facilities, and I've seen a rendering of the latest version of the patents proposal in the newspaper the other day that looks different than this, but I have visited at least 4 cultivation facilities. And I mean, these are industrial style uses. Again, they're not considered agricultural uses under state law. They're much more akin, in our view, to conventional industrial uses like asphalt plants, recycling facilities, the kinds of things that are always subject to very stringent zoning in order to protect neighbors and communities from impacts. To the best of my understanding, there are 5, maybe 7, but these 5 that I'm aware of that are current approved active cultivation facilities. I've been to 4 of them: Georgetown, Amesbury, Fitchburg, and Franklin. They're all in industrial zones. Now, I recognize that Hamilton doesn't have an industrial zone, but it just to give you an idea of where, the type of facility we're talking about. And I'd invite any of you to, if you're in any of these areas, to check them out yourselves, to see what these are like. These are industrial facilities. The one in Franklin is in an industrial park that abuts a dog walking place that I spent a little time at recently, and the odor is really unbelievably bad. And again, these are industrial type uses, underscoring the fact that in Hamilton, given that there is no industrial district, it's even more critical in our view to prudently regulate this industrial use outside of an industrial zone, which obviously Asbury is. So I'm going to go through these quickly because again, just for time. Noise, exhaust fans, truck traffic, slamming tailgates. There's a lot of truck traffic that'll be occurring. There's a loading bay that I know is part of the, rendering of the facility, security alarms and the like. So noise is a concern of the neighbors. Odor, and I know there's been talk about a filtering system. My understanding, and having researched some of this, is that there isn't a filtering system that completely eliminates what is a very pungent skunk-like odor that I experienced myself visiting the Franklin facility recently. It sort of hangs in the air, and it's extremely unpleasant. I think it would be extremely unpleasant for people, for example, wishing to use the Patent Trust facility for functions and things like that. It seems incongruous to us. And, the end use here is medical and not recreational. I noticed in the article the other day that Mr. Patton had said that the plan at this time is to only sell for medical purposes. It really doesn't matter in terms of the impacts, what the end use is. The impacts are the same with regard to these kinds of issues emanating from the cultivation facility. Visual impact, it's not pleasant to look at. It's like having a factory next to single-family homes and condos, and it's going to diminish the value of the neighboring properties, ruining curb appeal, and we'll get into diminution. For security reasons, most of the facilities that I'm aware of, and I believe that there's some provision for this in the host community agreement in terms of 24/7 security. That means outdoor lighting, so there's a concern about lights that'll be on all night long, and the impact that will have on Patton Ridge and on my clients, the Abbotts, in terms of light trespass. Water usage. Cannabis is a very thirsty crop. I don't know what numbers have been run thus far in terms of water usage, but it's bound to be very large volumes of water that would be used at the facility, and we wonder, how that will square with what we all know and, who live in this area, that we have to deal with every year in terms of increasingly more restrictive water usage restrictions. Wastewater, again, I don't know whether the plan is to do things like reverse osmosis, which is known to create toxic chemical byproducts. What types of wastewater will be created from this industrial processing facility, runoff control, what chemicals are used, and what impact would all of that have on the Ipswich River. We've been in contact, in very early contact, with the Watershed Association to ask them to help us understand what some of those concerns may involve. The host community agreement really doesn't address this at all. And the provision that you mentioned, Patrick, I think in terms of reopeners for unforeseen impacts, when I saw that, the first thing I thought of was this, because it doesn't seem like this has been studied. And I think that, again, you know, obviously environmental permitting is separate from special permits, but as of now, as of right use, I mean, there doesn't seem to be really have been much thought put into what types of environmental approval should be and review should be taking place. Ipswich River obviously is a water drinking supply source as well, as you know. Safety risks, we talked about security. Marijuana obviously is a very valuable product, particularly when it's stored in bulk. It's, you know, known as a magnet for robbery. There are a lot of security concerns that have yet to be worked out as legalized marijuana gets rolled out in Massachusetts. It is added burden on the Hamilton Police Department, and it, you know, is transforming what we all know is a quite, you know, beautiful bucolic environment there on Asbury into a high security environment. All of these impacts are going to diminish the value of properties. I mean, I do this for a living, and I know that it certainly, you know, won't be difficult to find many different appraisers who would look at this and quite clearly conclude that there would be a demonstrable drop in property values. I think it's common sense. None of us would want to live next to a marijuana cultivation facility, I would imagine, and that kind of thing is obviously what drops property values. And my clients are, you know, certainly very concerned about that. And I think local realtors would probably agree that this is a very legitimate concern. So our request is that you don't prejudge the Green Meadows Farm proposal. It's no secret that my clients, you know, have concerns about it and don't want it there. But on the other hand, what we're proposing in terms of a bylaw recognizes that you need to create an overlay district if you were to pursue that. And we realize the reality of that would be that if you were to do it, that the overlay district would include this area. We're not saying create an overlay district on Willow Street or something like that. We recognize that it has to be someplace. And if there were to be a bylaw, which we would urge you to consider, that this would be the overlay district, and maybe other places too, I don't know. But so we realize that's the reality, but what we're asking you to do is to put in place a conventional special permit process that merely allows for the weighing of impacts in the community as would occur with, you know, any other type of high impact use, creates a fair process for people to have input, which, let's face it, you know, site plan review, it's public meetings and so on, but it's a lot different than a special permit review. It keeps much more planning and control in the town's hands, which is appropriate for this kind of use. Insists on rigor, best practices, accountability, not an as-of-right type of situation. And you would be joining the vast majority of other Massachusetts municipalities in more prudently managing this type of use. So we would ask the board to you know, work with us to put forward a zoning bylaw for medical marijuana that could be teed up for a vote at the next town meeting. I really appreciate the board's time and giving us the amount of time that you have. Obviously happy to answer any other questions. At the chairman's pleasure, I know Mr. Grand Pré would like to speak as well, so perhaps this is the time for him to do that.
Actually, could I ask
We have a few questions first, and then we can.
Yeah.
Okay. Thanks.
Yeah.
Go ahead, Peter.
I just want to know, to what
Can you
extent
speak
is-
into the microphone?
I thought it was. To what extent is this an agricultural activity? As you painted a picture that it's going to be industrial processing and a lot of waste byproducts and so forth. I didn't know that that was it. I thought it was some horticultural activity. So does the proponents of the project describe it, and that would be helpful to me.
Sure, we can speak to that a little bit. Let's go ahead.
Yeah, microphone, please. Yeah, please. Yeah.
I know Paul wants to speak, Paul Grand Prix, but I'll wait.
Yeah, I want to address a few questions, then we can.
Yeah, I don't want to interrupt the flow, but my name is Bob Patton. I'm the CEO of Green Meadows Farm. With me sitting down is Chris Sawaki. He's my stepson, also our COO. This is Sean Costello of Costello Construction, who is our general contractor. I'm going to pass it on to Sean briefly, but one thing I did want to point, and I appreciate the conduct of Attorney Timons and all the Patton Ridge folks we've met. Chris Abbott I've met once. This is America, and everyone's been a total gentleman here, and I have no issues with any of that. I promise you. I did want to make one point, though, and I think Attorney Timons misspoke. There was no loophole that the Patton family created or was created for the Patton family. We had our farm here, so we decided to apply in Hamilton, and it turned out there was a way to go forward. We don't seek a loophole. We don't deserve a loophole. All the rigors that are represented by bodies like this we will have to meet and expect to meet. So I didn't want that to be left out there. And the last thing, my own experience with HCAs and my own understanding of it is that and I don't, not a lawyer, but we've been through this with a number of towns now. They are indeed the local oversight mechanism, and they wield a great deal of power. I won't say if it's the same as a zoning law and all the rest. I can only say that in dealing with Southbridge, where we have now attained one for our dispensary there, we're going through the process in Chicopee and in Framingham, and we have inquired in other towns, and it was never presented to us as a fait accompli. You have to go and apply, and the bodies that decide, the town councils, the city councils, the boards of selectmen, as the case may be in those towns, they wield the power, and it wasn't as if we could come in and simply dot the I's and cross the T's and we would get it. I could be wrong, maybe that's the way it is in other towns, but in all of our experience, we had much to meet, and there was always, and continues to be in the towns where we haven't gotten it yet, an idea that we may not rate, we may not be approved, and we understand that. That's the process. So Sean wants to mention briefly about the processing. We do have applied to extract cannabis oil for our medical product, and we are only going to be a medical provider of our HCA, and that is, as our attorneys and as our understanding and our approaches, that's part of the agricultural process. It stays there. It's simply compressed, and oil is extracted out of it that can then be put into the kinds of things that are much more preferable in medical administerings, i.e. not smoked, but in edibles and vapor and topical creams and such. So I'll step aside. Sean can have a brief word with maybe a little bit about some of the process, but this isn't the time to go point by point. I know that, and I don't want to begin that tonight. I promise.
Yeah, we're just looking.
Really
very general overview, I think, is what your question is.
Yeah, I don't want to go, because there's a lot in there that it's not the time to go into. So go ahead, Sean.
Yeah. So I think there were a few assumptions made in the presentation. We appreciate, obviously, how thorough it was and all of that. But the facility that we're talking about is an agricultural use facility, essentially. We're talking about a greenhouse facility, not an industrial complex that has chemical uses and all things of that nature. Some of the buildings that have been built to date have been built in that capacity. They've been built like industrial facilities, and they're very different from what we're proposing to do, essentially. So we are basically staying on the tenet of being an organic farm. There'll be no chemicals being used in terms of the growth of the plant and things of that nature, because that's part of the mission statement of the Patton family as an organization. That being said, it's going to be an organic farm in that sense. So we're doing it differently from the current status quo and the rest of the industry, and that's one of the appeals that we're going for in terms of the way this is being built. So,
but it's an organic farm and processing center.
That's correct. That's correct. But the building itself is a greenhouse. It's not a closed building, which is a lot of the buildings that are being built right now are industrial buildings. So they're commercial roofs, basically, with large air handling equipment and lots of noise and eyesore and things of that nature. We're not going in that direction at all. This is a completely different building. So this is a greenhouse structure. There have been greenhouse structures on that property for 50 years in the use of organic vegetables. So we're not differing really from the farm's original use in that we're just doing a larger version of a greenhouse. So.
And what is the processing then to get the oils out? What's
It's
that?
a press, actually. So it's no more than a hydraulic press. There's actually no chemicals involved or anything of that nature. If we were going to pursue anything of that, we would obviously, you know, talk about those, bring those before the board and talk about what those processes are and you know, give full information, full disclosure on what those would be. But we don't, at this time, have any intent on anything of that nature, so.
What kind of odor would be created as part of a press? I'm thinking of, and I have been around olive oil factories, and I know they're, you know, they may do a comparable kind of processing.
So those rooms that that extraction takes place in are actually rooms that have filtration. They have double filtration systems in them through the HVAC equipment, and they're also much smaller areas. So basically, that room, as the exhaust air goes out, it's filtered as it leaves the building. So it's filtered as it comes in, it's filtered as it goes out. So.
In fact, I could just say, again, this is not the forum for this, I apologize, but one of the things that we've learned through experience and talking with other greenhouses across the country is they say they forgot to filter the air in the extraction area. Right. Everybody thinks of the plant area, and the plants have the fragrances that come off of them, the odors, whatever you want to call it, and they say, whoops, we forgot about the extraction. It has correctly, and so that's something that we know going in. So we, as part of our HCA, the HCA is full of nuisance abatement clauses, and noise, lights, traffic, I mean, that sort of thing, all included in that, and smell is top of the list.
Right. We're in the process of designing those systems now, so they'll be part of, obviously, what comes before the board for permitting.
Question, do you know when you will be coming before the board for a site plan review?
Everything takes much longer than one thinks going into this. It's a complicated business. We're dealing with the engineering firm, Fuss & O'Neill. We literally are only sort of, in the last some weeks, sort of established the size that we think is optimal so we can avoid all of any setback issues with conservation and all that, and we'll have to prove that among many boards. You don't have to take my word for it. And Fuss & O'Neill, Sean, our architects, will be able to set up those pre-application meetings. They know it's above my pay grade. They'll be spearheading all of that. I'll be there, but I can't really tell you the answer to that. But we hope to commence it in the next weeks and months, and hopefully, God willing, if all the things, and depending on how you just imagine the zoning question here, to be permitted sometime in the spring, we hope, and then go forward from there. But those are out of our hands, and as you well know.
Well, this is material to this discussion, so because the special permit that the attorney presented would have to go to, has to be drafted, public hearings, and then would have to go to town meeting.
Understood.
We don't know when that'll be. Could be April, late April, early May. If you bring a site plan review in, we're already in that process. We can't deny you a hearing for that. So the special permit, and you can't go back and say, well, now you've got to go to a special permit. So you would be grandfathered into a process. So it's important for us to understand in evaluating this decision when you expect that to happen. So to the degree that you can be as specific as possible, it would be helpful to us in understanding the process.
As I say, we want to begin the pre-application meetings, which is, I understand, the terminology of what the Fuss & O'Neill, our folks there, and our architects, and Sean too, would be there, and as soon as possible to present, a site plan and the early kinds of things that we'll do with all the septics and those kinds of things soon. We hope to push it right through the winter as whatever sequence of meetings and become permitted as soon as possible. We could be in the spring would be wonderful, and that's the hope. I mean, it's a difficult process. We know it's complicated, but we do want to go forward. We're ready to go as quickly as possible. We now have locked in with our greenhouse manufacturer, and we're doing the design, interior design, all the important mechanicals, the MEPs, all that sort of thing to present. And again, I'll start to wander in areas where I don't really know all the details as far as how it's done. I just know that we're making the decisions now to present it to all the appropriate bodies as soon as possible. And also then to the public. Our last meeting, by the way, included a landscape architect, as well as, why? Because aesthetics are important to us, screening, plantings around it. It's a very important part of our application. I don't know if that answered your question, Mr. Mitchell.
As soon as possible.
As soon as possible.
We're working on the drawings now.
Yes.
Well, I understand that, but and with all due respect, I'm trying to understand just so for our purposes, because this is an important consideration. We have a special permit request. We also will have you at some point coming in, so to the degree that you think it's January, February, March, April, clarity is important. So I understand you want it to happen as quickly as possible. Time is money. I'm just trying to get more specificity. Do you think it's 3 months?
To begin or to end?
To come before the board with an application to go
sooner than that.
Sooner.
Sooner than that.
Within 60 days.
Within
Okay,
60 days.
thank you. That
Sorry.
helps.
Yeah.
That
I should have
helps.
answered that way. Maybe I should have. Apologies.
Okay, thank you.
Brian, could I ask a question? How do you fertilize your organic crop?
How do we well, the fertigation has not yet been decided because that's a process that happens actually with the grower, who is the person who is in charge of, taking care of the plants, maintenance, growth, all of that. But it is all organic, and it comes from a local provider, basically, yet to be determined. But the fertigation is all is done within the building, basically.
But organic fertilizer means using organic
Correct.
fertilizer.
No chemicals.
Right. No chemicals.
You're not using any chemicals?
None.
No, sir.
No chemicals.
No, sir.
No. This is completely organic.
And it's not
correct.
hydroponic.
No,
No.
it's not hydroponic.
No, we'll be in
No.
soil.
Yep.
Now, you're in the Ipswich River aquifer, so it is of some importance what fertilizer you're using and what it's going to have on the town's water supply.
Yes.
We're working out the numbers on the water right now. The current design incorporates a drip system, which actually does not use anywhere near as much water as some of the other designs.
Water's not a problem there. You've got an abandoned well there by the town that has
right.
many gallons of water.
Yep. We're exploring that as a supplementary option to have redundancy on site, as well as a cistern system.
We have a
for
roof water retention system
Yep.
with cisterns underneath.
Yep. So we're going to retain roof water as well, and that's going to also work into our drainage
You-
plan.
I've avoided answering my question. How are you going to fertilize your crop? You say it's with organics. Organic what? Horse manure? Cow manure?
I can't answer it yet because I don't know what the grower has decided, but it's up to him, actually. But he knows that obviously being an organic farm and whatever product he chooses has to fit into that recipe.
Thank you.
Yeah, the grower we have brought on is an organic grower from Colorado who'll be moving to Hamilton with his wife and 3 kids under 10 to assume control as director of cultivation. Wonderful man with a fantastic record, and he is an organic grower, strictly.
Yeah, it's kind of like defining an open-range chicken, you know.
Right.
Understood. I think.
Can I have a question?
Sure.
When you're doing the fertilization and watering and everything, will there be water runoff through
that's
the
captured.
soil that you're using to grow the plants in and out into the environment, or?
No. Any water that's used actually within the structure, because of, like I said, how efficient the drip system is, we typically have floor drains, and the floor drains then go basically to retention, where that water is then either repurposed or used as gray water for any other purpose, but it's clean water because it, like I said, it's not, it doesn't have any chemicals in it. So
you could actually recycle it back through.
Correct, and we've done that before.
That's what we do.
We've used that as gray water, basically, and we've used it for toilet flushing or other purposes that are acceptable, basically, to repurpose that water.
I might remind you that floor drains are illegal.
They're illegal unless they are attached to a retention system that then recycles the water.
A processing process, so you...
Right.
All right.
Yep.
But you just can't put a floor drain in a building.
That's correct, yes. But the whole system will be designed, and we'll show you what the actual design of the system is and how we plan to reuse that water.
You don't, at this point, know how you're going to fertilize your crop. But that's
I don't grow it, I just build the building. So.
Yeah, We'll know. We'll know. We'll have
Yeah.
all the answers
Yeah.
for that. I apologize for not having it tonight, exactly what we'll use,
We'll-
but,
yeah, we'll be able to answer that stuff
Yeah.
in the future. Yeah. Not so distant.
I just have a question. So what, my assumption then is that because of where this project is going, that it's in some sense going to happen before a bylaw.
For a special permit.
Yeah, yeah.
That's what it sounds like.
That would be my guess.
There's typically a 90-day period after town meeting if a bylaw, zoning bylaw passes in order to have the Attorney General approve a bylaw as well.
Well, and if the process has been started, even before it's passed too, I assume that it's grandfathered in if there's been an application.
Yeah.
Yeah.
Okay, so that kind of answers the question as it relates to the Patton Ridge and Patton property concerns. I understand your client would like to get up and make a comment?
Yes, and I think there's some other Patton Ridge folks here as well, but they can rise and speak if they want to.
Hi, good evening. Paul Grand Prey. I'm at 12 Patton Ridge. I'm on the homeowners board at Patton Ridge, and I wanted to emphasize the concerns of the neighbors because this is such a high impact use. I don't want to understate that at all. The odor is an acrid skunk odor from the cultivation of marijuana. Lighting, both for growing and security. The state, as I understand it, requires 24-hour security and security lighting. So there's some real concerns about light pollution. The fact that this is not an industrial design but a greenhouse design means you have a greenhouse roof. So you have light coming up through the roof, which causes us some concerns as well. And then the security issues and noise of a facility, and these are, you need air handlers to filter the air coming in and going out. So there are going to be noise implications. So this is a high impact use that could have significant impact on various areas within the town. So on behalf of the homeowners, not just of Patton Ridge, but of the town of Hamilton, we really ask that the planning board agree to adopt some rules and regulations to control and manage the marijuana growing and processing business in town. Thank you.
Hello, Bill Olson, 419 Highland Street. I just want to make a couple comments. As a previous member of the planning board, current member of the selectmen, been part of all these discussions. I want to make a few. These discussions are great to have. Welcome discussions. The points he made. I think that you got in every scenario you got to look at the worst case scenario and the best case scenario and sort of meet somewhere in the middle and make it work. So you don't create something in the town further down the road it'll create issues. But a couple things I just want to point out. One is that it's a rigorous process to do anything in this town. Between the planning board, the selectmen, health department, all the approvals. So, like said before, nothing's just going to get through and get approved. It's host agreements where it starts. We also don't. I would probably don't recommend that we create. Like we don't do spot zoning. We shouldn't do spot zoning bylaws. We shouldn't create a bylaw just for a single. We should look at it holistically, look at it thoughtfully, and make sure that what we do isn't just about one situation. It's about, so it's jumping back and forth between what they're doing, but it's really not. It's what we got to look at. What so if we want to take a step back and look at what the town needs, maybe we should do. But it's hard to make that conversation to something that is already sort of marched along. That sort of goes to my next point. That Chief Stevens came to us proactively over a year ago. He's the one who proposed the recreational marijuana bylaw. There's no loopholes, and it was his words, his research. Did a lot of research, presented to the planning board, presented to the town, presented to the selectmen. So it came from Chief Stevens. So he's a very thoughtful person. Created that bylaw, passed very easily at town meeting, and just want to make that clear. It wasn't created to create loopholes for any specific project. And the last thing is a host agreement was a very thoughtful process as well, very rigorous. A lot of discussions, a lot of open discussions, posted discussions, a lot of input from the abutters to create the 16-page document. Addresses everything that people brought up at the meeting. There's a 14 or 15 item site plan, specific items that regard lighting, odor, noise, waste, water. It's all in that. It gets reviewed during that process. So none of that was missed, none of that was forgotten about. It's all in the process. So I think that, you know, the Pattons have been a, you know, to make this about that is wrong. They've been a great member of the community for a long time, worked with the community, are willing to have given up a lot for the project. So it's hard to go back and forth between creating a bylaw to protect the town versus a bylaw to punish them. So I think we have to take a step back and realize what we're trying to do here. So, any questions?
Great. Thanks, Bill.
Hi, Craig Walker, 7 Patton Ridge president. I just have a couple of questions to ask. I think I wanted to ask you, does the state regulations and bylaws, you know, does it cover a lot of the issues brought up here? In other words, would it help to, what you're proposing is a state regulation as opposed to?
So there are proposed state regulations for the Cannabis Control Commission. There are also some regulations already in effect through DPH. None of them have to do with local zoning. They leave that entirely to cities and towns, which again is why, you know, most cities and towns have put forward in their bylaws a zoning scheme for medical marijuana in an overlay district that, you know, that does what the selectmen said to, you know, try to manage that policy townwide. But to answer your question, no, the state regulations don't speak to these issues. There are a couple of small exceptions, like there are parts of the law that deal with distance from schools and things of that nature, where under state law you can't have a facility within some certain distance of a school or daycare center. So there are a couple of things like that, but nothing to the level of granular detail that would come forward through a zoning process in a town.
But would the town benefit by some of these guidelines, informing some of their own policies?
By the town creating its own policies?
No, by having state guidelines.
Oh. Well, the state guidelines are the state guidelines. I mean, they're in effect. They, you know,
would the town benefit by that? In other words, would it help the town, you know, make decisions, prudent decisions?
Sure. I mean, I think it certainly, everyone should study the state regulations, understand what they say. I mean, they're the law, they're going to apply. So, yeah, the more people understand them, the better, but they don't really speak to the kinds of impact concerns that I've addressed.
Would the planning board object to that for any
Object to, what are you asking?
More state, well, basically more state regulation on it.
Well, I think I mean, correct me if I'm wrong, any facility has to follow the state regulations. What you're saying is there could be other regulations the town imposes or any town imposes zoning-wise on something like this. The state is the state. Mm-hmm. They have their regulations for these types of facilities and others. We could have additional zoning regulations for these types of facilities if we so chose. I think maybe what your question is does the state have recommended bylaw, zoning bylaw, or model bylaw for medical marijuana like they do for other types of facilities? Which I don't know if they do yet.
Well, so that guidance document that I quoted from, and some of the slides, that provides some guidance to towns. Some of that is guidance in the nature of, you know, here's what you might want to put into your zoning bylaws if you have a zoning bylaw. And then the school and daycare example is one where the state has set out a limit of, again, I don't recall the number of feet or yards, but let's say it's, you know, 500 yards. And then many town bylaws shrink that number, and they're allowed to. I've got a case involving a medical marijuana dispensary in Mansfield, and Mansfield took that number and made it, let's say, 100 yards. I don't recall the exact numbers, but made it more stringent than the state requirement.
Second question. When Topsfield withdrew and the site changed, the location and where it was originally proposed, you know, through the plans board, there were 2 facilities. Yes. How did that process happen? When you proposed a new site, or, you know, a modification for the site, moving it away from the hill, more towards the road. How did that take place? Did that go through the plans board?
No. Nothing's been to us yet.
I mean, it's, for us, it was just the right location to make our proposal. It will be others who will decide if it's a worthy site. We wanted to be away from all the possible conservation issues and Ipswich River issues, and it seemed to be a very good site to put it. It's farther away from Patton Ridge, as a matter of fact, but we chose that site because it seemed to be the
So
best
that
site.
hasn't been approved yet, is that right?
No, we have to go to a permitting process. Yeah, that's what we'll be doing here.
Right.
Yeah.
Nothing has come before this board yet in terms of this project.
Yeah, and that's why I was asking the question when they thought they would be bringing a site plan, they would make an application for a site plan review, which would address all the concerns that you and your attorney and others at Patton Ridge have expressed, because those are issues that we would go through.
I'm not being represented by the attorney. I'm just here as a
But you're at Patton Ridge.
President.
You're at Patton Ridge, right?
Yes,
Okay. So that's the answer to your question. So it was, and that's why I was asking about it. I don't think the board in general has a problem thinking about some sort of new zoning regulations. But as I understand it, and it's not you, the attorney's client would like this to be brought before town meeting, I believe the next town meeting. And my point was asking the Patton family when they would be submitting their application under our current zoning.
Okay. The reason I ask is because some work has been done there, I think tree removal and...
they took down the building.
Pardon me?
And they took down the greenhouse.
Yes, sure.
That was all permitted.
Well, yeah. So I had wondered whether or not a new site proposal had already been done and reviewed. And the last thing I just would like to know is it your will to have that loophole in the, as it was stated, in the, is that something that you're really aware of and advocate rather than, my understanding based on what you were saying was that you still have the right in the city to have, they have the right to have a dispensary there according to...
No, they do not. A medical marijuana growing facility cannot locate a dispensary in the same town it operates in by state law.
Okay.
You have a facility in where?
Southbridge.
Southbridge is going to be their dispensary.
Okay. Do you plan in the future, though, to have dispensaries? Are you thinking about having further processing plant? Agricultural growth and maybe processing in the town, and maybe have dispensaries?
Well, you're asking multiple questions, so
I withdraw.
So
It'll come up in the program.
I don't think we have any intent of any of those, but I think as Bill Olson, Selectman, pointed out, it was the police chief who drafted the prohibition against retail marijuana facilities in the town of Hamilton, but included the potential for a medical dispensary. But a medical dispensary would have to go through, again, a regulatory review process. Part of the problem I have just speaking to my fellow board members and the audience is an overlay district per se. As soon as we bring up the concept of an overlay district, we start naming the people in town who are subject to that. So it would be like going to Patton Ridge and say, hey, we're creating a Patton Ridge overlay district and you're it. So it engenders a huge political discussion, and I'm.
That's why you want to limit or preclude it from this discussion.
Well, one's procedural. One's procedural, because if the applicant comes in with a site plan review before we have whatever we do in the future, we have to honor that. So we can't go and say, okay, we'll do a special permit at the next town meeting and say, well, it now applies to your application, that once you make an application, you're in the queue, we have to use our existing zoning.
Your grandfathered in, yeah.
You're grandfathered in.
Okay, okay.
So that's why I was asking that question, is to get clarity when they expected to bring it in. So I was trying to decide wow, is this special permit something we have to really act on quickly, or is it something we ought to think about more carefully and have thoughtful discussions about what is it we want to regulate and how do we want to regulate that and where do we want that regulation to apply? Because I'll use an analogy, and it's a poor one, but I think it's apt. It's like using zoning overlay district and say, okay, we're going to put all affordable housing in this district, right, and nowhere else in town. Well, how do you think the people who live there feel about that? You're imposing a solution on a small group of people. It's the same thing with the commercial district. If we say, well, it can only go in the commercial district, well, they're going to go, wait a minute, A, there's no space down there, and B, why are you making us the people that, bear the burden of this? So we have to think about how that impacts the town.
So, thanks for taking the time to answer. I don't want to take any more time on that, and so I'd like to be respectful of that. Thank you for taking the time.
Thank you.
So it could be that the towns that have such zoning bylaws are ones that actually have industrial districts, because they don't run into that, and we don't have an industrial district to put it in.
Exactly. Really.
Can I make one quick comment? Just however, right now, effectively, the entire town is the overlay district because it's as of right anywhere in the town, and our point is that that may not be something that you would want to allow stand, given that zoning is all about creating districts.
I think the challenge is creating the district and whether that's possible.
Well, we think that this area probably would end up being the district, although not the way Topsfield did it with just one parcel. But obviously there's several steps to that would be taken before that would happen. And just to conclude on my part, we would very much respectfully urge the board to take that under consideration and move forward with some sort of zoning bylaw for medical marijuana and with an overlay district.
Thank you.
Thank you.
Okay. Anything else from the board?
I think the processing is the thing that, for me, it's a surprise. I thought it was just agricultural growing, and the processing has entirely different side effects and considerations that we don't even know what they are.
Right.
We will when they put in a site when they submit their application. You will.
Yes, but if the application's coming in before we have a bylaw, that is not going to work.
No, they have to go through a site plan review, and if you read the host community agreement, you'll see that it's very clearly stipulated what they have to review, as well as our own bylaw, and they have to pay for a independent consultant to the planning board to verify and validate whatever they're presenting to us. So it's not going to be a mystery. So while you don't understand it now, and I don't either, the whole point is, so we will.
Right, and some of those provisions aren't typical of a site plan review, like the outside consultant. It is of a special permit, though, as we know. The only thing is special permit you can deny.
Right. Yes, I understand that. We hold the trump card.
Yep. Okay. Great. Thank you for everything. Absolutely. Okay. Is there any update on our master plan, or quick update?
Quickly, the consultants are working on the town's demographic profile right now. They're also preparing reporting on housing characteristics here locally. They're also looking at development constraints and analyzing that community-wide. They will be providing a draft report to us in middle December. Another point, too, I know that some of the selectmen have been assisting in selecting the focus group individuals. I haven't seen that yet, but looking forward to seeing that begin its process with those folks.
Just an update on that. Sean Farrell, Chairman of the Board of Selectmen, did send me something today. I haven't opened his list, but I'll forward that to you. And
Great.
Okay, I'm going to table the discussion about future bylaw amendments, given it's 9 o'clock almost, so we'll do that next time. Has everybody had a chance to read the minutes from our last meeting on the 13th, last week?
I'd like to say this about the minutes. For a very complex meeting, the minutes were done very well.
Yeah.
Is that Marcy Rico working on that now, or is that?
She's the one.
Yep. You want to make a shout out to her?
Make a what?
I think you did already.
do you want to shout out to her? What a great job she's doing?
That's what I said.
I'm just kidding.
Okay. Any issue with the minutes?
I'm not prepared to, well, I wasn't here, so I don't have anything to say about it.
I was not here either, so I won't comment.
Patrick, I sent you a thing about something that I didn't understand that I was reading.
And I clarified that after you did.
Yeah, I thought so.
Yeah,
I can't find
I did
it.
some editing.
It was on the first page, right?
Yep.
Thank you.
First paragraph, in
First
fact.
paragraph. Yeah.
I'll make a motion that we approve the November 13th, 2018 minutes.
I second.
All those in favor?
Aye.
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 Unanimous of those of us that were here. Any other updates? Hearing none.
Make a motion, we adjourn.
Second.
All those in favor?
Aye.
Aye.
Aye.